Please be seated.
Good morning, everyone. And we were examining Dr. Long, cross-examination, when last he was on the stand. So, Mr. Albee, you may continue.
Thank you, Judge. Dr. Long, you recall we discussed defense exhibits 125 and 126. 125 was just behind you. Let me zoom back here. That bottom graph is a mass spec, correct?
Yes, sir. That's the mass spec of the peak that occurs. It looks like 6.262 minutes.
And this is 12B, the blood, correct?
Yes, sir.
And this is the kind of graph that you referred to as a fingerprint, correct?
Yes, sir.
And there are reference books that have the peaks you should get for ethylene glycol, correct?
Yes, sir.
And when you go to the reference book, they have a single set of peaks, right? I mean, that is, if you go to the reference book, they have a mass spec for ethylene glycol, 1, correct?
Yes, sir.
They don't have multiple different charts for mass specs of ethylene glycol.
Well, they may. They may, depending upon how complete the text is.
What do you typically see when you go to reference books?
Well, you can have one is the parent drug, or you can have the parent plus a particular derivative, which would be a common derivative that's used.
Okay, but if you're looking just for ethylene glycol, you'd expect to see one mass spec reference.
No, you might see it, for example, a derivative means you take a chemical and you add it to the compound that you're looking for, and it joins it up, and it gives you a different molecular structure. That is called a derivative. So the parent drug doesn't give you the same spectra. It is the derivative with the parent that gives you the spectra.
And but you're looking to match the ethylene glycol mass spec you get with a reference spectra, correct?
Well, that's why we run a standard. We take a known standard and run that, and then we derivatize.
Right, and you can compare it to a reference too. That's something you've done, right?
If the reference matches up to the derivative, yes, sir.
And your explanation for 13B and 12B being different was that there is some what you call grass, correct? This is 13B, and you've acknowledged the peaks are different than in 12B, even though they're both ethylene glycol in the blood.
Yes, sir.
And those are the peaks are the fingerprints, as you called them.
Yes, sir.
When we left off last time, Dr. Long, I had asked you about a case you had done, Patricia Stallings. Do you recall that?
Yes, sir.
And in that case, you presented evidence at trial, correct?
Yes, sir.
And you presented a mass spec chart similar to the one here, correct?
Similar, yes, sir.
Based on the testing that you had done in that particular case, correct?
Based on the testing that was done 20 years ago, along with the other data that had been presented by other laboratories.
Was it based on what you had done in that case? It was based on the testing you had done in that case, right?
That's what I presented, yes, sir, at that time.
That's a yes, right?
That's what I said.
Well, you had some extras, so I just wanted to make sure it was a yes.
Objection. Counsel's arguing with the witness.
May I ask you a question?
And Dr. Long, in that case, you showed a chart that compared the results you got based on your testing in that case, and you compared that to a reference spectra, correct?
Yes, sir.
And
That was Exhibit 15.
And what you did in that case is you took the spectra from the samples that you had done in the Stallings case and you whited out some of the peaks, right?
I whited out 3 numbers on the graph, and I wrote one of them back in.
So you whited out 3 numbers.
Yes, sir.
And you did that so it would look like a better match, right?
I was asked to do that by the prosecutor, and that's in the transcript that you have.
And the reason that that was done is so that it would look like a better match for the jury, true?
No, the actual mass ions were not whited out. The identification or the presentation of them, that number was whited out. They were still present, it was still interpretable, it still had an XY axis, so everything was there to make a full interpretation of it. Just the presentation took these 3 numbers off, one of which I put back and I put another number on.
You were asked whether that, it was a blown up, Exhibit 15 was a blown up chart, right?
It was actually 3 parts, yes.
One of those 3 parts was a blown up chart of the spectra from the sample you had tested in the Stallings case, right?
Yes.
And that's the one that you whited out numbers on, true?
Yes, I told you that. I whited out 3 numbers, I wrote one back in.
Dr. Long?
Yes.
That's the one you whited out numbers on, true? The
Yes.
spectra for the testing in that case. And then you were asked by the prosecutor if your chart that you were showing in blown up portions to that jury was a fair and accurate representation of the spectra that had been produced by the testing, right?
Yes, sir.
And you said it was a fair and accurate representation, right?
As a scientist, yes, it is a fair and accurate representation.
Did you testify outside the jury's presence last week?
Yes, sir.
And then, at that time, did you say that it was not a fair and accurate representation?
Well, I don't know what I said.
You didn't tell the jury that you had whited out numbers, right?
Objection, Your Honor. He wasn't asked in front of the jury whether he
Not this jury. You didn't tell the jury in the Stallings case. Pardon me?
In the Stallings case.
In the Stallings, yeah. No, it was a good clarification. It's my error. You didn't tell the jury in the Stallings case that you had whited out numbers on Exhibit 15, did you?
I wasn't asked, sir.
Did you tell the jury that you had whited out numbers on Exhibit 15?
I said no, I wasn't asked.
And when you were asked, is this a fair and accurate representation, did you tell the jury that there were some exceptions to how fair and accurate it was because you had whited out numbers?
No, sir, I told you. And I still consider it fair and accurate.
Is there any evidence that you've manipulated in this case that you haven't told this jury is fair and accurate?
No, sir, I didn't do any of the work on this case. The analysts did the work. They interpreted it. They recorded it in their own handwriting, and then I reviewed their data.
Did you think that was a complete representation in that case, in the Stallings case, Exhibit 15?
Complete? No, because the numbers had been whited out.
You would acknowledge that you should not have done that, right?
You're right. I should not have done that.
You
I
know
was
that as a
misled.
toxicologist, you should not have whited out those numbers on the spectra, right?
That's right. I was misled.
And you should not have told the jury that it was a fair and accurate representation without qualification, right?
Well, as I said, I still consider it, as a scientist, a fair and accurate representation. I think you're looking for some legal term with that I'm unaware of exactly what you mean. Was it identical? No, it wasn't. I did white it out.
I want to know if you think you should have told that jury that it wasn't exactly the same spectra that had been produced during your testing.
Well, your question assumes that he did tell the jury that it was exactly the same.
Well, you told them it was a fair and accurate representation, right?
Yes, sir, as a scientist, yes.
I understand you're saying that as a scientist. Do you think you should have told that jury that you had whited out numbers when asked if it was a fair and accurate representation?
I think it would have been better, yes, sir, at this time, because I never should have done it.
That would have been the right thing to do, correct?
I should have done it, but I can only answer what you ask. I should have done it.
And when the prosecutor asked you to white out those numbers, you should have said no, right?
That is correct, sir. I should have said no.
I'm going to show you Offense Exhibit 123A. Oops, I guess I can't do that. And Dr. Long, this is a letter from Mr. Jambois to me, correct?
Yes, sir.
And in that letter, it was represented that Dr. Long will testify that the presence of a very large quantity of almost pure ethylene glycol in the stomach, 660 milliliters, combined with a very small amount of ethylene glycol in the blood, and in turn combined again with a large amount of ethylene glycol in the urine and the presence of oxalate acid crystals in the kidney, caused Dr. Long to conclude that Julie Jensen had received a minimum of 2 doses of ethylene glycol, 1 dose that had been fully absorbed, and then a final dose that had been administered very late in the 3rd stage of ethylene glycol poisoning at a time when she would have been either unconscious or semi-conscious and, in any event, entirely unable to get out of bed, ingest the ethylene glycol, conceal any evidence of it, and get back into bed and die. Is it your testimony that Mr. Jambois' representation that you would testify to the presence of a very large quantity of almost pure ethylene glycol in the stomach was just a misunderstanding between you and Mr. Jambois?
I believe so, yes, sir.
Do you deny ever telling him that?
I don't see why I would have said that because I never did the calculations. What I did was we found 4,000 nanograms per mil in the gastric and 50 in the blood, or rather micrograms. I did it again. So by comparison, yes, it's large. In the absolute sense of how much is in her stomach, no. It's half a teaspoon. It's not a large amount.
You didn't do the calculations, right?
I didn't do the calculations.
And Dr. Long, you said a large concentration at one point, right?
Well, I use large amount and concentration pretty interchangeably.
You should not do that as a toxicologist, should you?
Why not?
You understand that amount and concentration mean different things, right?
Well, amount can go to the total, excuse me, but we use concentration so much. And what am I going to say? Amount is used. Maybe
I would like you to say, if they mean different things, I would like you to tell this jury that they mean different things.
Well, concentration is an amount, okay? But an amount is a concentration. Sometimes they refer to different things, such as the amount in the gastric means the total amount in the total gastric, which is a small number, half a teaspoon, okay? However, the concentration in the gastric is large. It's about 4,000 micrograms per mil. So while the concentration is high, the total amount is low.
Dr. Long,
Yes, sir.
could you answer the last question? I would like it read back.
I thought I did.
If you can answer it yes or no, please do.
Question, I would like you to say if they mean different things. I would like you to tell this jury that they mean different things.
Objection, Your Honor. The witness answered the question. And I don't think that was a question that lent itself to a yes or no answer, but in any event, the witness answered the question.
What I would say is that I don't know if the witness answered the question or not, in the sense that there was excess material in there, explanatory material, and I guess what would be prudent would be for doctor to try to distill it into a shorter answer that would be more usable to lay people.
Do concentration and amount mean different things?
I can't answer that yes and no. Can they mean different things? Yes. Do they always mean different things? No. Sometimes an amount is a concentration. Sometimes an amount is different.
Well, that's like saying sometimes an animal is an elephant, but it's not always an elephant.
No, sir. No. And as I explained, when you have a total
There's no question in front of you right now.
When you have a total amount, okay, that's one thing. So that would be, say, the concentration in the gastric total. So that is an amount. Whereas you could have a concentration per each part of the gastric, or an amount for each part of the gastric. So they are relatively interchangeable. They can mean different things, but generally they're pretty much the same.
Whoops. I got a big mess of everything here. Exhibit 131, Dr. Long. You recall that concentration was something less than 1/220th of the total contents of the stomach?
Yes, sir, of the ethylene glycol. Yes,
Right.
sir.
Less than 1/220th
Yes, sir.
of what you call large concentration, correct?
Yes, sir.
And you would acknowledge that you should not have used the word large, true?
True.
And we went through how an amount can mean something different than a concentration, correct?
An amount can mean something different.
Right. And in this case, you said it was a large amount, meaning that the total was large, right?
Well, no.
Answer yes or no. Did you say a large amount? Well, go ahead.
Meaning that the total was large.
Not with that meaning, no, sir.
I understand. You're going to tell us once again that you were comparing it to the blood concentration, right? Or the blood amount, the amount in the blood.
Yes, sir. I said that to you last time, innumerable, and I'll say it to you again, innumerable. That's what I did. I didn't do the total calculation. I didn't quantify how much the total amount for the gastric was.
And you didn't, that explanation isn't anywhere in your report, is it?
No, it isn't. It just says I made the mistake.
You never told anybody about that explanation until defense experts pointed out that you had made a mistake, correct?
Well, I guess so, yes, sir.
You didn't know you made a mistake for 3 years, right? 2 years?
No, I didn't know how it was being interpreted, sir. And when I saw how it was, I realized I was wrong.
Well, you hadn't ever even done this calculation, right? You had never even done this calculation.
No, I hadn't, sir. That's exactly right.
That would take you, what, 30 seconds?
Approximately.
10
yes, sir.
seconds of the calculator?
Well, maybe 30 seconds.
And that's why you were calling it large amount and large concentration in the report, right?
Okay. Yes.
And that's why, and you thought it was, as Mr. Jamboy's letter indicates, that the majority of the contents in the stomach were ethylene glycol, right?
No, sir. I didn't do that calculation. I didn't look at it. I told you what it was. It was the amount in the gastrics, the concentration in the gastric, to the concentration in the blood. There's a huge difference. That's what I was looking at. That's what I was talking about. I wasn't talking about the concentration of the total gastric or the amount.
Dr. Long, you wrote in your report that Mrs. Jensen would have been too weak to drink the volume of ethylene glycol that she consumed, correct?
Yes, sir.
And you've acknowledged that she wouldn't have been too weak to, for example, consume half a teaspoon, right?
She could have consumed half a teaspoon, yes, sir.
And she could have consumed a glass of water, an 8-ounce glass of water or ethylene glycol, right?
Yes, sir, she could have.
And so when you say she was too weak to consume the volume of ethylene glycol in her stomach, you mean at least something greater than 8 ounces.
No, sir, I didn't mean that. I told you this, and we can go over it again, but I told you what I said, I told you why I said it, I told you what I meant, and I should have done the calculation in the gastric. That would have clarified all this up months ago.
Years ago.
Years ago.
You still haven't done an amended report, correct?
Actually, yes, I did.
When did you do that?
It was faxed up here yesterday.
Oh, so now you've fixed all this by doing an amended report?
Well, you kept asking me about the amended report. I didn't see any point to it, but I did one.
You do acknowledge that you said too weak to consume the volume of ethylene glycol.
Based on the history, yes, sir. And
that means you believed the amount in the stomach was greater than 8 ounces, given that you just said she could have drank 8 ounces.
She could have drank 660 milliliters, sir, because that's what's in her belly at the time of her death.
Then why did you say in your report she was too weak to consume the volume of ethylene glycol in her stomach?
Because I believed she was too weak to consume anything, given the history, which did include the vomiting and the nausea, and she was on all fours and all the rest of that. So all of that was included.
Dr. Long, do you recall that we went through the vomiting and that she had not vomited from the bedroom to the bathroom?
Okay, according to the police reports that I have, that is correct. I received a letter from Mr. Jamboy explaining where it came from, that it was from one of the police investigations and that he had been informed of it. And I either got it from him or from Dr. Mainland, but that's where I got it. There was, go ahead.
Well, you wrote your report before Dr. Mainland was even the Kenosha County Medical Examiner.
I may have gotten it from Mr. Jamboy then. I don't know where I got it from, sir.
You have your file with the police reports, and there's no such police report, is there?
It's not in the police reports, that's correct.
What you did is you mistakenly took the information in Dr. Borman's letter about vomiting from the bedroom to the bathroom in November and transposed that to December is what happened, right?
That's reasonable, yes, sir.
Let me show you again Defense Exhibit 15. I'm going to move 15 into evidence, if it's not already.
Any objection?
No.
It will be received.
This is the, let me zoom in on that a little bit. I'd asked you about BUN levels the other day,
Yes, sir.
and you said that that it should have been 4.
No, I said less than 10. I believe that's what it's stating up there, is 4 is their target.
Okay. Actually, the 4 reflect, if you go to the comments section, 4 just simply says that it's vitreous humor fluid.
Yes, sir. I misread it.
Okay, so it's not, there's no claim that it should be 4, right?
That's correct.
And this is an area in which you said you hadn't done any work recently, correct?
That's correct.
That's all I have.
Well, doctor, let's go through this, go back to the Exhibit 15 that was in that criminal case 20 years or so ago. And looking behind you, and I guess I gotta zoom it up here a little bit. Is that Exhibit 15?
Yes, sir.
Judge, I would move for production of this document, which I have not
Oh, I'm sorry.
seen or been given.
Since he was examining the witness, I thought he'd seen it. So here it is. Here's Exhibit 15. Here's the original report.
Are these different?
Well, this is what it looked like.
I see what you're saying.
I guess I should have those marked as exhibits anyway. I will do that when counsel's done examining them. And just to cover our base here, I'm going to show you these exhibits first before I publish them to the jury. Directing your attention to State's Exhibit 207, can you tell us what that is?
This is a copy of the Exhibit 15 that was used in the criminal prosecution in the Stallings case.
And then directing your attention to Exhibit 208, can you tell us what that is?
This is the template that was used to make this exhibit. So this would be actually the original work that was done.
Now, let's, and the portion of these two exhibits where the only changes occurred with respect to the top portion of A, is that correct?
Yes, sir.
Okay. So here we have Exhibit 208, and this portion right up here is the portion that you've been examined about in this case, correct?
Yes, sir.
And then here is Exhibit 207, which is the original Exhibit 215, putting one underneath the other, correct?
Yes, sir.
Now, can you see that clearly up there?
Yes,
Doctor?
sir.
Now this top portion, there's a number over here, 281, correct?
Yes, sir.
And tell us what that is.
That's just a mass ion.
What is the area of, now when you're in the field of mass, when you're talking about gas chromatography, is there something called an ion of interest? Or,
Yes, sir.
Okay, tell us what the ion of interest is.
The best way to put it is if you have dandelions in your lawn, they're the ions of interest in whatever else is out there. In this testing, the ion of interest, it represents the drug or the fragmentation pattern from the drug.
Now, and I'm going to, Your Honor, do you have one of those pointers, the laser pointers?
Yes. One for you and one for the witness.
Thank you so much. Okay, I'm going to give you the harder one to use because, well, actually, they're both pretty easy. Here, there's yours,
Okay.
and here's mine. Now, could you, using your laser pointer, point out on this exhibit where the ion of interest is on the Exhibit 208, which is the top chart?
There's actually two. There's this one right here, and then there's this one right here, which is marked 43, and this one is the 62. Those are the ions of interest for the ethylene glycol.
Well, what about this one over there, the one that's marked 281? Why aren't you interested in that one?
That's an extraneous molecular ion. It may represent, because what we were injecting into the instrument at this time may have washed something through, may have been something extra that just came through in the baseline noise. It can be any one of a number of things. Could be another compound. We have no idea what this is, but we're not really looking at that to see what it is because of all the options. What we're looking at is to see, do we have the ions for ethylene glycol?
Now, comparing State's Exhibit 15 to
That's 15.
State's Exhibit 15 from the Stelling case, which is the lower chart down here, comparing to the one up here, what I see is, first of all, the 281 was erased out or whited out. Is that correct?
Yes, sir.
And why was that?
I was asked to do that by the prosecutor. He felt it was confusing to have these other numbers up there.
Now, does that, the whiting out 281, does that detract in any way from the accuracy of the representation over here?
No, because also here you can see the molecular weight's 200, 250, so you can see it's about a 281 if you were ever interested in it. So the data is intact. The presentation of it isn't, because here's the 281 that was erased or whited out.
And then looking at, there's another number 94 here that was whited out on the exhibit down here. Is that correct?
Yes, sir.
And what does that 94 represent?
Again, it's another stray ion. It's something, we have no idea what it is.
And it doesn't, and its presence or absence, does it detract in any way from the accuracy of the findings in this case?
No, because again, here you can see, even though it's not labeled as 94, you can see there's 100, so you know it's about a 94. So you can still do it. You can also see the relatively low abundance here of 6,000. That's a low abundance. So really what you're looking at is stuff way down, very low.
But then this portion over here is the portion of interest to you?
Yes, and here if you notice the 43 was whited out because it looked confusing to him. So he said, why don't you put the 43 and label it, and then the 62 and label it, because the 62 was not labeled. So I put these two on here, and I whited out that and that.
Now, does Exhibit 15 in the Stallings case fairly and accurately depict your findings with respect to the quantity of ethylene glycol in the substance that you were examining?
Yes, sir, it does.
Can I be allowed to see those?
Oh, sure, I'm sorry. Now, Dr. Luan, you, at some point, you were, in fact, during pretty much this entire case, you have retained possession of the samples that were tested at your laboratory. Is that correct?
Yes, sir, the samples that were taken and sent to us by the Kenosha County medical examiner.
And at some point, a number of months ago, you were asked to package up portions of those samples and send them to another toxicologist of the defense's choosing. Is that correct?
Yes, sir, AIT.
And did you ever get any reports back indicating whether or not AIT's results were consistent or inconsistent with yours?
Objection to the relevant. Overruled. Yeah, I withdraw the objection.
Regarding ethylene glycol, no. They apparently did not test for ethylene glycol. They tested the gastric contents for the presence of other drugs such as Paxil, Ambien, and others.
But they never tested for ethylene glycol in the gastric contents?
No, sir. If they did, I didn't get a report on it.
Did you also send those samples of those items that you had in your possession to Dr. Gumman in Milwaukee?
I don't recall that. We could have.
In any event, all of these items that you've tested in your laboratory could have been made available for the defense to test independently themselves if that's what they chose to do.
Yes, sir. That's why we hold on to things for at least 2 years now.
Now, aside from your use of the term large concentration, as opposed to small concentration, aside from that, has anybody questioned the actual findings? In other words,
Objection.
well, have you ever had reason to doubt or suspect the accuracy of your findings, your determination that there were 55 micrograms per milliliter of ethylene glycol in the blood of Julie Jensen?
No, sir.
Have you ever had any reason to doubt or rescind or revisit your conclusions of your laboratory that there was 3,940 micrograms per milliliter of ethylene glycol in Julie Jensen's stomach contents?
No, sir.
Has anybody ever, and I forgot what the amount was in the urine. Do you remember what the amount was in the urine?
No, sir.
But has anybody ever brought to your attention any reason to doubt the results of your laboratory concerning the amount of ethylene glycol in Julie Jensen's urine?
Objection as to any need to bring to his attention anything.
Well, as phrased, sustained.
It's burden shifting.
Well, there's been a great deal of discussion on cross-examination about your mistake or mistakes in this case. Aside from using the word large in describing the concentration of the ethylene glycol in Julie Jensen's stomach contents, are you aware of any other mistakes that you made?
No, sir, nor that I've been accused of.
Now let's talk.
Objection to the witness volunteering the answer that was.
Strike the last clause, the last clause. Strike the part, or that I've been accused of. Conjunction and everything after. I'm drawing a blank.
Oh, let's use this for a second.
Sorry, Counsel, could you back that up just a couple feet? Are you able to do that? Thank you. That's good.
Now, and actually, I guess I am going to have to, and I fear we're going to be testing my mathematical skills here for a second, but let's talk about large versus small. The blood in Julie Jensen's, well, Julie Jensen's blood tested at 55 micrograms per milliliter. Is that correct?
Yes, sir.
And counsel has indicated that comes out to about 1/220th. That's the concentration. Is that about right, would you say?
No, that was in the gastric, the fourth.
Oh, I'm sorry. That's right. That was in the gastric. So that wasn't. So let's talk about the gastric. Gastric was 3,940 micrograms per ml. Is that correct?
Yes, sir.
And can you read that from way back there? Maybe I should make my 9 a little bit clearer. And that equals 1/220, right?
That's compared to the total gastric, yes, sir.
And 55 micrograms, boy, I don't have a calculator here. Does anybody have a calculator? But let's
I don't know what it is, but
because I was going to divide 55 by 3,940. And that will give you the ratio, the difference in the concentrations between the gastric and the blood, right?
Yes, sir.
And that comes out to, boy, I can't see what the decimal point is here. I need my reading glasses, but it's a pretty small number. It
Object to the
comes out,
prosecutor testifying.
okay, well,
Did he couldn't see the number? I'm just going to give him a check later.
okay. Here, it comes out
See the
to
decimal.
0.0139593. Just to make sure that you agree with that description, that's what it comes out to, right?
Yes, sir.
So the ratio between if you compare the amount in the blood to the amount in the gastric, the ratio is this amount. And then if you multiply that times 1/220, that's going to give you the comparative ratio between the two. That's, in other words, let's take 55 micrograms per milliliter and just do the math and convert that to a fraction. What would the fraction be? And it should be this amount times That amount, wouldn't it?
Yes, sir.
So if you were to multiply this amount, if you were to divide this amount by 220, it would be much smaller than 220, correct?
Yes, sir.
Let's figure out, let's see if we can figure that out. So can you take 55 micrograms?
Good enough. Is that good? You good enough?
I should,
Such a
yes.
small decimal.
Yeah.
Well, let's take 55.
Just to, go ahead.
Yes.
Can you convert 55 micrograms per milliliter to a fraction? I mean, I can't do it because I don't know enough about my brother has all the math skills in my family, so.
Just for 1 milliliter. Whoa.
And I didn't say I was going to give you this test, did I?
Yeah. So that would be 55 micrograms. The milligrams. So that would be no, there's a 0 in there. Well, if I'm doing this correctly, the fraction would be 0.000055 divided by 1. So that would be the fraction.
0.0005?
55.
55?
Yeah, there's 4 zeros.
Oh. 0.000055
Yes.
divided by,
1. That would be
One.
the fraction.
oh. Well, I don't even know what that would come out to, but it's a lot less than 1 out of 220, isn't it?
Yes, sir.
Maybe, in fact, I came up with something like 1 out of 17,600.
Those are different fractions.
I know. Let's say, I understand, but when I took 55 micrograms per milliliter and compared it to 3,940 micrograms per milliliter, and they say this is 220, this would be approximately 1 out of 17,600.
Doing it that way, yes, sir.
So if you're going to compare 1 out of 220 is a pretty small number, isn't it?
By comparison, yes, sir.
But you compare it to 1 out of 17,600, 1 out of 220 is a pretty large number, correct?
Yes, sir.
So when you're comparing, when you're saying large and small, 5 pounds would be a pretty large rat, right?
Yes.
Be about an average cat,
Yes.
and it'd be a small dog.
Yes.
And it doesn't really communicate a lot, does it, when you just say 5 pounds and you're saying whether it's large or small?
Correct.
So when you're talking about a large concentration or a small concentration, it's all relative, correct?
Yes, sir.
Now, tell me this about concentrations of toxic substances in the body. Does the body, as it metabolites the toxic substances, does it tend to seek to equalize the ratio?
What it does is an equilibrium. Okay.
So, when we're talking about an equilibrium between concentrations, here we have the stomach, and in the stomach it was a concentration of 1 over 220, right?
Yes, sir.
And here we have the blood on the outside, and the concentration in the blood is, here, I'll put it over here, 1 over 17,600, right? Now,
Yes.
at that point, as you're saying it's reaching equilibrium, is the ethylene glycol going down in here and going up out here until they equalize?
That's called absorption. And that's what routinely happens. It goes
So-
into the stomach and then is absorbed into the bloodstream.
So, when you're talking about comparing the concentrations in the blood to the concentration in the gastric contents, the fact that there was a much larger concentration in the gastric contents as compared to the amount that was in the blood, what that means is Julie Jensen's body was still absorbing ethylene glycol up to the time of her death.
Yes, sir.
And that's because the amount of the concentration of ethylene glycol in her stomach was much larger than the amount of ethylene glycol in her blood.
Section to the leading.
Sustained.
Well, did I get that wrong or did I get that right?
Well, that's still asking
No,
the
I think
question.
that actually
was
makes
the
it a non-leading, especially to an expert witness. Overruled.
Yes, you got it right. It goes from a higher concentration to a lower concentration, not the reverse.
Now, doctor, if I were to offer you this hypothetical factual situation, if I can tell you hypothetically that Julie Jensen was exhibiting the signs of ethylene glycol intoxication in the evening, Tuesday evening, December 1st, and into the early morning hours of Wednesday, that there is evidence that she was vomiting most of the day Wednesday and couldn't keep anything down, and that she was found dead on December 3rd, 1998, in the afternoon hours, with exactly the amounts of ethylene glycol in her gastric contents, her blood, and in her urine that you have found. Do you have an opinion to a reasonable degree of scientific certainty as to whether or not Julie Jensen had one dose or more than one dose of ethylene glycol in the hours and days preceding her death?
Yes, I do.
And what is that opinion?
She had multiple doses. The first dose produced the intoxication, it produced the crystals that were found post-mortem, and what's present in the gastric shows a second dose, or at least two, maybe more.
Explain your reasoning to the jury as to how do you come to that conclusion based upon those hypothetical facts?
Well, because, first of all, she was described as appearing drunk. My understanding is she didn't drink. So that is one of the first signs and symptoms of intoxication. The next sign and symptom is she was vomiting, and there was reports of her vomiting and couldn't keep anything down. That would empty out anything in the gastric, so nothing's going to be there. Furthermore, the time passage, it's going to be eliminated. If you have lunch today, it's not going to be sitting in your stomach tomorrow. It's going to be gone. Gastric emptying time ranges 2 to 3 hours on an average sized meal, maybe a little larger. Excuse me. So anything in her gastric should have been gone. The fact that ethylene glycol was found at the time of her death shows at least one more dose was given. Plus she had all the pathology, which requires a minimum of 12 hours for it to appear, and that's the crystals.
Now, doctor, at some point I was asking you earlier about the chain of custody with respect to the gastric contents. Did you have occasion to examine the bottle that the gastric contents were received in at your laboratory?
Well, I had them photocopy and fax it up here.
And what did the fax and the photocopy show to you in terms of the chain of custody with respect to the gastric contents that you had received at your laboratory?
I moved for production of this document.
Well, we're looking for it. I don't know. I packed things up several times, so I don't know where it is. We'll see if we can find it. If I find it, I'll produce it.
Well, let's take a break because we're going to stop at 11:20 anyway, so now would be the right time. Please don't talk about the case. This is going to be about 10 minutes.
He did give it to me.
I believe, based on the testimony here in redirect, that I ought to be able to get in that he was wrong in his diagnosis that it was ethylene glycol in the Stallings case, because they've now shown this, they've used extrinsic evidence to show this Exhibit 15 to suggest that, well, there's nothing wrong with doing these kind of procedures, and again, trying to I think, bolster the witness's credibility and qualifications by showing that any of his actions wouldn't really have any negative effect on the fairness and truth of the proceedings. And fact is, mistakes get made in the lab, and just to say the fact, just to say the fact is, your finding that it was ethylene glycol in this case is incorrect, I think is a fair question.
I'm going to deny your request because the only extrinsic evidence, as you say, that they used was the very chart that you relied upon in your impeachment. And
hadn't even received this. And I just asked the question about whether he had whited out the chart.
well, they have a right then to show the chart. And by the way, the rule does not preclude the proponent of the testimony from producing extrinsic evidence. Only the impeacher, as I read it.
In any event, I didn't produce any extrinsic evidence, Your Honor, regarding the Patricia Stallings case. All I did was produce evidence that was precisely to refute the proposition that he had somehow misled the jury earlier by producing the exhibit that counsel was cross-examining the witness about.
Well, I take it back. What I said, the specific instances of the conduct of a witness for the purpose of attacking or supporting the witness's credibility may not be proved by extrinsic evidence. To me, it was not extrinsic evidence because you directly examined, you cross-examined him, I should say, about the chart in question, and he didn't bring in an extrinsic source to sponsor the report. He actually asked the doctor about the report, with which he was personally familiar during the redirect examination, so your request is denied.
Which was interesting, because he didn't seem to know nearly as much previously.
Argue it to the jury.
Also, I guess I need to know if they're intending to introduce a report that I haven't received, which he volunteered that I think now exists.
I wasn't planning to introduce the report, but I don't even know where the report is. Again, we packed up all our stuff this morning to get out of the hotel room, so I've got stuff in a bunch of different boxes. I can probably produce that report for counsel's review if he gives me a few minutes to find it. But
Oh, if you're going to talk about it, I think you ought to produce it.
I wasn't going to talk about it.
All right.
He asked him about it in cross-examination.
I found out that there's a new report today, so I get it.
Yeah, I
mean,
think
that's
you
required.
should give it to him.
I-
Have you got a copy, Doctor?
No, I don't think so, Your Honor.
It's a one-page, one-paragraph report, and I'll seek to find it. If I can't find it, then I'll ask the doctor to. Do you have a copy of it back at your lab, doctor?
How much change is there? Is it just the word large, or is there more?
He's just talking about that.
How much content is there in the change that's new?
Well, why don't we find it and we'll produce it? And
There really isn't much change in content at all. It's only about addressing the word large.
And I apologize. I'm not trying to withhold you, and I just can't find it. It's
What fax machines were involved?
I think it was sent to the Walworth County DA's office. It would have to be.
I'm sure it's still on the memory of the machine.
You know, actually, I've got a copy of it. I know I've got a copy of it down there, so I'll go get it.
Go get it and make a copy for Mr. Albee.
I will do that. Doctor, I show you this document. It's marked as State's Exhibit 209. Can I ask you to identify that?
Yes, this is a copy of the bottle of the gastric contents from Julie Jensen that were sent to us.
We went through this before. I guess until something's admitted, the witness should be published on his own.
Okay.
Sorry, Your Honor.
So just identify it first and tell me what it is, and then I'll move for introduction.
Okay, these are photocopies of a bottle of gastric contents from the laboratory.
And does this photocopy truly and accurately portray that bottle as you recall it?
Yes, sir.
Your Honor, request that State's Exhibit 209 be received into evidence.
Could I just see which, I have a stack of photocopies and I didn't know which one you're using.
Well, they're all. It says the whole stack is being marked as one. Are they? See, they took the bottle, put it in the photocopier, and turned it, and so they got the whole label on it.
I guess I don't object to the admission subject to establishing that this is the gastric copy.
Okay, well, take a look at it, examine it, look at each page of it, and then tell me what it is. Good question. And no, it's not. Thank you.
Yes, this is a copy, photocopy of the bottle that was faxed up here by Joe Crafassi, who did the mass spec work and the analysis. Excuse me. And what it shows, can I show it?
Yes, it's been admitted into evidence, Your
I'm
Honor.
sorry, which one are we talking about?
It's Exhibit 209 is comprised of several photocopies.
Okay, this is the first page. It shows the bottle, and unfortunately, photocopies aren't that good. But it shows our label here. It shows the 89-1177 case, and you can see the end of Sen for Jensen and Julie. That's our label that we put on it. Excuse me. And here it shows ethylene glycol, and I can't really read the date on it. Okay, this is the side of it, which shows really not much of anything. Here is the other side where it starts out saying subject and then collected by, and you have doctor. And then it says date and time, 12/4, okay? And then when it's turned,
Yeah, see that?
okay. Then the next one shows that it's Jensen, and finishing off Lee, L-I-E, for Julie Jensen. And at the end of doctor, collected by, it says Chambliss, and the date is kind of illegible. And that should be their number there. I don't know. It's not ours, so I think it's theirs. This shows the cap, okay, which has, I believe that's their number, 99FX1608. Shows Julie Jensen, well, Sen and Julie. Doesn't show Jensen, the number's over it. And then this is just a better photocopy showing that it's Jensen and Chambliss collected it with 99FX1608. So this is a copy of the gastrics that we received, and the portion that we sent off to AIT came from here.
Thank you. And then we'll show you exhibit, what's marked as Exhibit S119. And the chain of custody begins on page 19 of that exhibit, is that correct?
Yes, sir.
Proceeds through page 20,
Yes.
21,
Yes.
and then 22.
Yes. Then it goes into the procedures. The first chain of custody was the sample chain of custody, showing how it was received. Is it here? Yes. Showing on the back, it was from the refrigerator for accessioning, and it should be... This is the air bill on how it was received.
Judge, and I think this is the subject of an earlier objection. This is all hearsay and Sixth Amendment, because none of this is this witness's personal knowledge.
Well, I think this issue does need to be further addressed. When we stop.
When we stop? Well, why not to have him examine and describe the contents of his own file?
Well, I think that part, but the Sixth Amendment, there is a lingering issue that was discussed previously.
I just need to know what I'm supposed to do next. I was going to have this witness describe, he's already gone through this report. I wasn't going to go through the whole thing again, but...
I think he can, I think I'm going to permit him to answer your question right now, but there is an overarching issue that we need to address.
And I have no clue what that might be, but I'm permitted to examine this witness. Okay.
The objection is to hearsay is overruled.
Okay. This is your file, correct, from your laboratory?
Yes, sir.
Your business records?
Yes, sir.
Records that you rely upon in the normal course and ordinary course of your duties as a forensic toxicologist at the St. Louis lab?
Yes,
correct?
sir.
And you've examined that, compared that photocopy to the original that was in your file, correct?
Yes, sir.
And I think S-119's already been received into evidence, and if it hasn't, I'd move it into evidence at this point.
Any objection?
Yes, I believe that's the issue the court was just referring to.
I'll withhold a ruling until that issue is resolved.
I have no further questions of this witness, Your Honor.
Mr. What's the place? Albee?
Not gravely, all.
Is there a marker around? Do you swipe one? Dr. Long, there's 55 micrograms per milliliter in the blood, correct?
Yes, sir.
How many liters of blood in the body?
About 5 liters.
And when I multiply that by 5 liters, what's the total amount of ethylene glycol in the blood?
When you have to multiply that by 5,000 liters, it's a milliliter, isn't it? A milliliter, a thousandth of a liter?
He knows that.
Well,
I'm not, you know how to do this calculation to do the conversion, right?
Yes, sir. It's 5,000. It comes out, excuse me, 275,000 micrograms or 275 milligrams.
I'm sorry, 275 milligrams?
Yes, sir.
And what we had in the gastric was 2.6 grams.
About that, yes, sir.
Is that right? And so that's about 2,600 milligrams in the stomach.
Yes, sir.
Okay. So the ratio, it's a little less than 10 times as much total amount in the stomach.
That is correct.
One more calculation, since we have a calculator today. Do you recall that it's about 2.4 milliliters of ethylene glycol in the stomach contents?
Approximately, yes, sir.
And with a total of 660 milliliters, can you give me the actual ratio? Because it was something greater than 1 out of 220th. You just didn't have a calculator to do it.
Grab this. So it was, what do you want to divide the total concentration by the milliliters?
Yes.
That should give us the concentration of 4,000 nanograms per mil.
micrograms.
Micrograms. 2.5 divided by 660. That gives us, I used 2.5, that gives us approximately 0.003 grams, which is micrograms, 3,787 micrograms per milliliter.
I think I've either asked the wrong question. I'm looking to try to get the ratio of the total contents that's ethylene glycol. And we have 2.4 milliliters of ethylene glycol and 660 milliliters of total contents. And I'm looking for what the ratio is. I had put 1/220th before, but that's on the low side.
So you're still talking about dividing the 2.5 milliliters of ethylene glycol by 660 milliliters.
Correct.
And that's still going to give you your 4,000 nanograms.
Well, I'm looking for a ratio, though. Let me try this. if we have 2.4 milliliters and you multiply that by 276, I think you get 662 milliliters. So do we end up with about 1/276th of the contents is
About that,
ethylene
yes.
glycol? Okay.
Yes, sir.
So 1/276th of the total contents is the ethylene glycol in the stomach, correct?
Of the total contents, yes, sir.
Nowhere in your report do you say large amounts is a ratio compared to the blood concentration or blood amount, right?
That's correct.
And that's not something you would typically do in any of the reports you ever produce, right?
I don't understand.
That is, you frequently talk about concentration or amount, of a substance in the blood or the gastric contents without making any reference to how much is in some other part of the body, right?
No, sir, we do that routinely. We compare concentrations in various tissues to the blood, to the urine. That's done routinely.
And then what you do is you indicate that it's a comparison rather than a total, right?
Well, I don't know that we indicate it's a comparison. It's sort of standard operations. That's what we do, sir. Or at least what I do.
Mr. Jamboys wasn't familiar with ethylene glycol before you talked to him, correct?
Objection, no foundation as to what I knew.
Fair enough. Mr. Jamboys asked you for assistance in understanding. Is that on, Tammy? Asked you for assistance in understanding the amount of ethylene glycol in the stomach contents, correct?
Well, we talked about it. I don't think he said, can you give me assistance in understanding, but
And you also had that conversation with Dr. Lavin, correct?
I could have had the same conversation with her, yes, or parts of it.
Okay. And as a result of that conversation, Mr. Jamboys indicated that you would testify that there was a very large quantity of almost pure ethylene glycol in the stomach.
That's what he
Objection,
represents.
Your Honor, no foundation as to how this witness would know what I based my letter on. That was my letter, not his.
It's,
I think you can cross-examine him about the letter.
That's what he represented to you, yes, sir.
are you aware of whether Dr. Lavin made any similar representations after discussing this with you?
I'm not aware.
You were asked about AIT laboratory. Are you aware that they do not do ethylene glycol testing?
No, sir.
You don't know one way or another?
I would assume they do, but I don't know specifically.
Well, you understand there are a number of labs that do not do ethylene glycol testing, correct?
But that is a forensic laboratory. It's a big lab.
Okay. Did you get results from the University of Kentucky?
Yes, I think they did some tryptase or something like that.
Well, did you get the results from the University of Kentucky on ethylene glycol?
No, sir. They didn't do a test for that.
Well, are you aware that AIT forwarded the samples to the University of Kentucky for testing regarding ethylene glycol?
No, sir, I wasn't.
Are you aware that they forwarded the samples to the University of Kentucky for testing for glycolic acid?
Yes, sir.
And you've seen
believe
those
so.
results?
I did see that glycolic acid, yes, sir.
And those were recent, correct?
Yes, sir.
You don't recall that those same tests showed ethylene glycol tests?
I didn't see any, I don't recall seeing any ethylene glycol. I saw glycolic acid.
Exhibits 207 and 208, reflecting your work in the Stallings case, show that you whited out numbers in that case, right?
Yes, sir.
You do not dispute today that you should not have done that, right?
That's correct, sir.
And you do not dispute today that you should have told the jury that you were whiting out those numbers, right?
It would have been better. I don't think it would have changed anything. Wouldn't have changed my opinions, but
you-
it would have been better.
But you understand that as a witness, it's not for you to decide what matters and what doesn't. You're supposed to tell the whole picture, right?
Yes, sir, I try to do that.
And that's why it would have been the right thing to do to tell that jury in the Stallings case that you had whited out numbers.
I wish I had, sir.
And you don't know, if you hadn't whited out those numbers, if that may have been significant to that particular jury under all the circumstances of that particular case, correct?
I don't know what would have been significant or insignificant to them.
In this case, you understand that the first reports of Mrs. Jensen appearing intoxicated were a little after 2 a.m. on December 2nd, correct?
I believe so, yes, sir.
That would be consistent, I think you said, with a consumption of ethylene glycol.
Yes, sir.
It would be consistent with a consumption of ethylene glycol whether she consumed it herself or it was given to her by somebody else.
Yes, sir.
You display the same symptoms either way.
The toxicity is going to be the same.
You are aware that the next morning she was talking on the telephone to a neighbor? Or the same morning on December 2nd?
I believe she was, yes, sir.
Do you recall reading the report where the neighbor reported that her voice sounded a bit weak and perhaps dizzy or intoxicated?
Yes, sir. I do.
And that would be consistent with a single consumption of ethylene glycol early in the morning of December 2nd?
Yes, sir.
True. At the time of Julie Jensen's death, she had crystals in her kidneys, correct?
Yes, sir.
That would be consistent with a single consumption of ethylene glycol, right?
That's possible, yes, sir.
Your concern is that the 2.6 grams in her stomach should not have been there, right? If it was a single consumption early in the morning of December 2nd.
That's correct.
We discussed the possibility that she used the same glass as she drank ethylene glycol from later, sometime later, correct?
We discussed that, yes, sir.
And that would be one possibility to explain that amount in her stomach, true?
Well, she would have had to have half a teaspoon left in the glass, yes, sir, or more.
And so that, yes, that is a possibility, correct?
Yes, that's a possibility.
The potato and pepper demonstrate, in your view, that she ate that day,
She may have been getting better, yes, sir.
shortly before death.
Yes,
She
sir.
ate.
She may have been feeling better.
She may have been getting out of bed.
She may have.
She didn't go to the bathroom in the bed, so she presumably was getting up to go to the bathroom.
That would be an assumption, yes, sir.
Are you aware of past case studies in which someone has had ethylene glycol in their stomach for at least 28 hours?
No, I'm not.
Do you have the chain of custody exhibit, the facts that you had received from your lab?
No, sir.
So you put it back. Oh, that one up there. Show you exhibit 209. I'm sorry, maybe I just missed it. Does it say gastric contents in that document?
It may not say it. I'm not sure here. You would know that by looking at it, though. And no, it doesn't say gastric.
You yourself did not examine the gastric contents in this case?
I didn't do any of the testing on the gastric. That is true.
Had you examined that bottle?
I didn't touch the bottle, no, sir.
So you personally are unable to say that that label's from the gastric contents?
Oh, I probably saw it in the possession of somebody else. I was probably present and saw it. But we can bring up real pictures of it when Joe comes up.
Do you recall that label is what I'm asking you?
I believe so, yes, sir.
So, and when did you look at that label?
Probably when it was pulled out of long-term frozen storage to make sure we had it, to send it out for AIT.
Do you recall looking at it at that time?
Well, I would have, by definition, because we were pulling things out of frozen storage.
So you did that personally rather than someone else doing it?
Well, I would have been helping, or someone else may have done it, but they would have shown me what they had.
Well, I'm asking if you personally, if you have a distinct recollection of personally examining that bottle at that time.
I have a pretty clear picture. Exactly when I saw the bottle, I'm not positive, sir.
When we talk about, again, your explanation of large, just referring to ratio, that still does not account for her being too weak to drink the volume, which is only a half a teaspoon, correct?
That's correct.
Ratio does not explain why you would say she was too weak to drink that volume, correct?
No, her history was.
The history that you were in error about because there was no vomiting from the bedroom to the bathroom, correct?
Objection, Your Honor. It's not consistent with the evidence in this case.
This cross-examination overruled.
It wasn't in the police reports, that's correct, sir.
It was your testimony in August that you thought there was you thought that she probably had been vomiting for hours, correct?
Is that my testimony in August?
Yes.
I guess so.
That was quite possible that she'd been vomiting for hours, right?
Quite possible, yes, sir.
And that you would expect her to continue to vomit as long as there was something in the stomach? Is that your position?
Yes, I believe that's what I said. And I believe she would continue to vomit unless she was getting better.
Well, at that time, you never suggested she was getting better, correct?
No, I didn't.
And that's sort of outside your area of expertise, correct?
I couldn't comment on that, you're right.
That's all.
Any request?
No, Your Honor.
You may step down.
Thank you, Your Honor.
You're going to break at 11:30, Your Honor. That's 11 minutes from now.
Yeah, I suppose now is the time then. We'll break now until 12:30. And please don't talk about the case during the break.
I know there was this issue that had come about the confrontation clause, and I know this was a long time ago that we were talking about this last, and I don't offer up my memory as any great thing, but I had thought that we'd address this issue and that we'd come up with the case law that clearly indicated that this witness could testify about the findings of the persons that worked in his lab. I thought I'd produced case law to that effect. That was my recollection. So is that what the confrontation clause issue was that you were talking about?
That was what I was talking about. I don't know whether that's what Mr. Alden was talking about.
I don't dispute Mr. Jamboy's recollection. I don't recall that the court had said that it's overruled. I agree with Mr. Jamboy. He raised that case. While I think at some point, I'm not aware, let me just say I'm not aware of any Wisconsin case law to the contrary of his case, which I recall being post-Crawford. I can't remember if after getting the case from him, if I checked if there's anything very recent, but I believe that is the current state of the law in Wisconsin. Nonetheless, because these issues are in flux, I've raised the confrontation.
I would say that the case, well, I'll leave that out. If there were some issue that you presented which pertained to that suggested a mishandling or misadventure in the examination and reporting of the results of the examination, other than doctor's summary that you've challenged, then I would be more receptive to your constitutional argument. I'm comfortable with the case that was cited, and I don't recollect its name at this moment, but when there's no issue advanced to the court about which the testimony of the subordinates of Dr. Long would be likely to be fruitful. And if you can point to something like that, then I would embrace your constitutional argument. But in the absence of that, I am inclined to follow the case.
I would just say that when you have testing of substances, and I've not uncovered anything. I don't know what they did during the testing, but that could be said for a lot of different testing of substances, that you get the information from the lab and there's nothing obvious on the face about any problems. And I just think because that's the central issue in this case, that the confrontation right exists. And I think there's also remains a chain of custody problem here that's somewhat interrelated.
Well, the chain of custody I felt was adequately dealt with by doctor in the testimony, which was introduced on redirect with photocopies. I don't recollect what those exhibit numbers were. But as I stated last time, the question on chain of custody is A, whether something's been tampered with, and B, whether the substance is what it pertains to be. I mean, just having I think I commented last time that I had a case where a witness testified that he saw 7 pennies in someone else's possession, and he knew that they were his pennies. And I think, well, that's pretty good. I think you actually have to establish a chain of custody then, so we know they are in fact the same 7 pennies. But I don't have any significant doubt, and I can't imagine, you know, if you can make some suggestion that there is some question as to that these are in fact the gastric contents of Ms. Jensen, or that they've been tampered with in some way, then those are issues that I think would invite a more in-depth chain of custody presentation. But in the absence of that, I'm not seeing it. And go ahead.
I'm sorry.
No, that's all right.
I didn't mean to interrupt. I think, I'm not saying that they can't establish chain of custody. I don't believe they have done so yet, because Dr. Shambliss couldn't remember specifically doing it. He didn't put it in the report, and the materials that were sent to the St. Louis lab did not indicate that they were sending gastric contents. And Dr. Long here has not, this label doesn't say gastric contents. So I think that's a bit problematic. And when you don't have anybody on the front end, I think there's a little bit of checks and balances. I think you need to show chain of custody on both ends, not that just somebody has something that purports to be the sample, but also that somebody collected it and sent it off in the first place.
But I think we are agreed that as the jury is instructed, facts may be proved either by direct examination, direct evidence, or by circumstantial evidence, and the arrival at the laboratory of some human remains that are labeled as Julie Jensen, collected by Michael Chambliss, December the 4th, I think it said, or maybe he said the date was illegible, creates a circumstance which I think it could fairly be interpreted that they are what they purport to be.
I understand the court's point. I think it falls short of that.
Okay.
Until there's somebody who says, we had them and sent them out. And
And by the way, I thought he said Dr. Lavin was in a position, or not Dr. Lavin, Dr. Mainland was going to be in a position to say something on the subject?
On which subject might that be?
That the gastric contents were in fact transmitted to St. Louis?
I don't know what you'll say. I would say this. Dr. Chambliss testified that, and the autopsy report indicates there was 660 milliliters of gastric contents collected. And that, well, actually present. It didn't say collected, it said present. It said there was 660 milliliters of gastric contents. That's what it says in the autopsy report. Then the documents from the St. Louis lab indicated that they received gastric contents from the Kenosha lab and that they tested it. So I think that we've established chain of custody. Have we established every little bitty link in it? No, but that doesn't go to admissibility, Your Honor. That goes to the weight that the jury's going to ascribe to it. And there's clearly circumstantial evidence that gastric contents was collected because although Dr. Chambliss didn't put in his report that he collected it, he says he typically would, and he does say that they've measured the 660 milliliters of gastric contents in his report. And then there's gastric contents tested at the St. Louis lab and received at the St. Louis lab. So I think we've established that.
As we have had reinforced with us in this particular case, the test for admission of evidence is the greater weight of the believable evidence, and I conclude that the greater weight of the believable evidence suggests that these were in fact the gastric contents of Julie Jensen taken at autopsy, and if you want to argue to the jury that the state hasn't proved beyond a reasonable doubt, you're welcome to do that, but I'm going to admit them without further inquiry on the chain of custody. And the other one was the confrontation issue with respect to the handling. Did you want to say anything further on that?
I'm not sure what the court's specifically referring to.
I thought you had a Sixth Amendment objection to...
You just said the handling, and I didn't know.
Well, when I say handling, I'm saying the test results. Well, isn't that what you...
Yes. Right.
Did you want to say anything further on that?
I thought that was the first part of things that we had addressed before I said chain of custody. That Mr. Jamboys had said, I thought that was dealt with because I have the Wisconsin.
Oh, I know. I'm sorry. I didn't want to.
Wisconsin case.
I wanted to see if you wanted to say anything further.
The case was State v. Barton, 2006, Wis. App. 18-709, Northwest 2nd, 93. And I don't need to read the holding since the court has correctly applied the holding in this case, which is that a supervising scientist can testify as to the test results on tests that were performed by persons under his supervision.
Well, I'm not sure I read it exactly that way.
Well, then I better read it exactly what it says.
No, I think the Court of Appeals knows what it says. They wrote it. I'm not sure I read it exactly as you did about the supervisor just reading it. I think there's more required, but I think that it's, as I say, substantially done in this case, and further that there has not been even the suggestion that of any impropriety or irregularity or lack of accurate scientific determination in this case, other than the summarization by Dr. Long. And so in terms of the quantities in that, the ratios or any of that, I don't think there's been any issue raised about that. And further, the material has been made available to the defendant for analysis had he wished to do so. And I think, I understand that ability to compel the attendance of witnesses is a different right than that to confront witnesses, but the availability of witnesses who could do an alternative examination and present evidence on behalf of the defense, I think has to be considered in conjunction with whether or not the defendant is being denied confrontation.
I would just say I do disagree with that viewpoint. I don't think there's any requirement of production on the defense ever to assert confrontation rights, and it involves expense and time and other things, and I don't think I need to bring anyone. I think if they want to sponsor a witness, it's their obligation to present a witness for cross-examination. I think that's what the Sixth Amendment requires. I understand the court's statement on that. I register my objection.
Okay. Did you want to say anything else on these subjects?
No.
All right, so the confrontation issue with respect to the testing employees is denied. The chain of custody objection is denied.
Now, what time would we be back around?
12:30.
12:30.
All right, we're going to handle. Jury's not present.
Did you find it then?
And what's up?
Your Honor, you've got Exhibit 210 in front of you, and I provided a number of photos that, in fact, I may as well have the rest of those marked as exhibits as well. Mr. Albee has indicated to me he has no objection to these photographs, which haven't been marked as exhibits, but will be short now. But he objects to the photograph that has been labeled Exhibit 210. So I guess we should talk about that. And I understand it's a graphic photo. It portrays Julie Jensen after there's been the traditional Y incision. The skin is reflected black, displaying the rib cage. And the purpose of having this photo entered into evidence is so that Dr. Mainland can show where the injuries on the rib cage are. And I think it requires expert testimony to show where it is, because I think to the untrained eye it might not be plainly visible. And then have her testify about how the injuries on the rib cage line up perfectly with the way that Julie Jensen's arm was arrayed underneath her at the time of her death, which is, of course, consistent then with Aaron Dillard's previous testimony concerning Mark Jensen's confession to him. So it's a very critical piece of evidence. There are obviously dozens of autopsy photos that portray the body of Julie Jensen in various stages of the autopsy, and we're not seeking to introduce those. I understand it's a graphic photo and it portrays something that the jury is not accustomed to seeing, but I believe that it's something that needs to be shown to the jury and something that needs to be entered into evidence.
Mr. Albee?
Judge, I think it's unduly prejudicial. I think that's a very difficult photo to look at and will have an inflammatory effect on the jury. What Mr. Jamboy seems to be explaining is that he would like Dr. Mainland to be able to identify precisely the area in which there's this small amount of hemorrhage. That can be done on a diagram of a body that's not cut open. And frankly, I think that would be more helpful to the jury, because they may not be able to equate what they're seeing here with the body torn open versus what they usually see with a body. I think a diagram will much better show where the area of injury is and be able to show the nexus between the arm and that injury that the prosecution wishes to show. There's nothing that will give the jury greater insight by having that photograph shown. If there is any value to it, I think it would be very minimal. But it is a very graphic photo and would have an inflammatory effect, and I think is unnecessary. I think the prosecution can demonstrate exactly what it wants to demonstrate without showing that photo, which I know this isn't a rule adopted by the court, but if I can't look at it for very long, then that's where I start to say that jurors are going to have the same problem. And I really struggle with a photo like that. I can't look at it for even 5 seconds. It really bothers me, so it's going to really bother some jurors. And I know that's not testimony for the court or anything, but it just, from my personal experience, and if it was more necessary, I understand sometimes those photos need to be admitted, but I think they can make the presentation without admitting it.
Well, I think that this exhibit, and I agree that it's really it depicts the horror of the loss of human life, but the suggestion that it is thereby going to inflame the jury to be more likely to find the defendant guilty is, to me, a non sequitur. And as I said, I think earlier on in the trial, the founders of our country were distrustful of judges, and they felt that people needed to have major decisions made by jurors, and so they put the jury system as critical, or as a right that everybody has in most civil cases and all criminal cases, and the judges have repaid the compliment over the last 218 years by suggesting that jurors aren't able to make logical and rational decisions under various situations. And what happens, I think, is that somewhere along the line, some case, there probably was an inflammatory photograph introduced, which may have had an inflammatory effect, and it's been expanded upon to the point that the suggestion is now made that somehow a gruesome photograph of a horrible situation is going to cause these unintelligent jurors to become inflamed and engage in illogical behavior, and I don't buy that. I don't think this picture is any more likely to convince the jurors that the defendant killed Mrs. Jensen than it is to convince them that she took her own life, except as it is supported by other evidence which suggests one or the other alternative. So to me, the photograph, though horrible, and though I'm sure the jurors will not want to look at it any longer than they have to, and I have to say I've been looking at it here because I don't, it doesn't come out to me what the district attorney wants to show is where these particular observations can be made. And of course, I'm used to looking at some of these pictures regularly with trying murder cases, but it'll have to be explained to me so that I'll understand it, and that's the purpose of it. And I think a chart is not an adequate substitute for that. And I think the jurors will be able to make a perfectly and rational, intelligent, and sensible use of it in conjunction with all the other evidence in the case, so your objection's overruled. Anything else before we start?
No, I would just say, I think because they do have to look at it for a longer period of time because it's not obvious, that increases that prejudicial value. They can't turn away immediately to see the presentation, and so I just think under 90403 it isn't admissible, and the court does have to serve a gatekeeper function. I think that's one of the constitutional requirements.
And I agree with the court having to do some review under 90403, but I reject the conclusion that you reached that it has a prejudicial component at all. So, anything else before we start?
No, Your Honor.
All right. Ask the jurors to come in, please.